one would be able to identify, but all of them were soldiers and duly trained by UPDF. So, my Lord, I feel and I submit that you by my fellow colleague in respect to identification parade. In the case of Uganda, of Baluk Samuel and another versus Uganda, 2018, it is the Uganda Supreme Court at page 26. Court held that it was irregular, so that failure to carry out an identification parade properly did not cause injustice to the appellant. This is because there was other evidence relied on to convict and uphold the conviction of the appellant. Here in this matter, Your Honor, the judge, it is a matter of the Supreme Court. The presiding justices held that even if there was improper or irregular exercise, or some procedures were not followed, as long as it does not cause injustice to the accused person, court can go ahead to convict using other evidence adduced by the prosecution. Honorable Chairman, the accused did not request the police that he wanted the services of a lawyer, and that was denied that right. He is a member of UPDF, Special Forces Command. And to remind the Honorable Court, the President of the Republic of Uganda, through an instrument, appointed members of the court and officers of the Division Court Martial, including the defense lawyer who is on my left here. And he's mandated by UPDF to represent the accused person, and of which duty he is exercising right now. He was available in the unit, and the accused did not request for him. So we shall contend that he waived that right, because it was his role, together with his lawyer, to request the person who was carrying the exercise that I am not going to manage, avail me a lawyer. That question was never raised. And 02, Uganda Supreme Court, number 14, the Supreme Court stated that it is trade law that minor inconsistencies, unless they point to deliberate unforcefulness on the part of the prosecution witnesses, should be ignored. And that major ones which go to the root of the case should be resolved in favor of the accused. And the same was considered in the case of Alfred Taja versus Uganda. It is a criminal appeal case number 167 and 1969. Ayaka is unreported. But each case, in this matter, the judge said that each case must be decided on its own merit. Meaning that when you want to weigh, as the Honorable Court, even civilians can see that really there was evidence or decision on its own merit. You'll find here this is a case where one stole a gun from the barracks. He didn't have a movement order. He was not authorized to move with the weapon. He tied the weapon in the mattress, rode a motorcycle up to areas of Oyam, and he was in possession, and by the time when the robbery and the murder took place, he was in possession of the gun. That gun had not at the time returned in the hands of the security. He later handed over the gun after knowing that he had committed offenses. My Lord, I'm blessing the accused, and I still contend that he's the one who committed the said offenses. I beg to proceed. And my Lord, I'm going also to address briefly on how the gun was recovered. This, which was placed, where the accused himself, after knowing that security was looking for him, he was not at the trading center. He shouldn't hoodwink the Honorable Court. There was an uncle who was in communication with the accused. is the one who informed him that security is looking for you. And the LSC chairperson, the head of the clan, he told court that he rang, the accused rang them, and he had a chance to talk to him on phone. And when he talked to him, he told him that the military is looking for you, kindly hand over the gun. Meaning that at that time, if court is to infer or to make a conclusion, the accused had already turned rampage. He was hostile at that moment. Because even the family members, all the friends in the unit, he called even in the unit himself as per when he was cross-examined, when he was a defense witness yesterday, he accepted that he called a Lance Corporal in the unit who was his friend to ask the situation in the unit. And the Lance Corporal told him that the situation is alarming, they are looking for you. All those allude to the conduct of that unbecoming of an accused person. Such a conduct is not for a prudent man. Your Honor will agree with the prosecution that the gun was recovered from a tree. He went and placed the gun on the tree. He went ahead to call the bullets. And when he was cross-examined by the honorable court members yesterday as to why there were two separate live ammunitions placed down on the tree, he informed them that there was a photo magazine. And how could one move, or how could one be given a photo magazine when he is going for duty? That one, Your Honor, when he was under testimony, it was a total lie. Therefore, when the gun was recovered from wherever he had kept it on the tree alongside Torch River, it was handed over to the district security officers. The district was in court, and he identified the gun. After identifying the gun, he rang Captain Oyam, who also came and took the gun. And when he took the gun, he handed it over to OC Investigations. That is, I'm giving accountability of the chain of the weapon that then the weapon ended up in the hands of the government, of the senior government ballistic expert. In that vein, Your Honor, the above evidence is also corroborated by the girl who was in court. Everybody saw the expert who came from Wandegea, he was in court, and he told court that on the 11th March 24, he received Exhibit A1, Exhibit A2, Exhibit A3, A4, A5, and A6. And those were cartridge casings. Also, he received Exhibit B, which was a live ammunition. And also received Exhibit C1, C2, C3, and C4, which were magazines. These were magazines these were 4 magazines containing bullets, and Exhibit D, which was an SMG rifle number 56610129 to the laboratory for examination. And the purpose was to establish whether Exhibit A to 6 were discharged by Exhibit D, meaning that whether those exhibits, the cartridge casings, are the ones which were picked from Loro Town Council, foreclosed, and Exhibit D is the gun which was recovered from the tree. When the expert was in court, after carrying out examination, he found out that the rifle was capable of shooting ammunition, because during the time of examining the rifle, there was the barrel was tested positive for gunshots residue, implying that the rifle has ever discharged ammunition at some point prior to submission for examination. I will make it this, Honorable, my Lord, very clear that the gun before submitting it to him, it had already discharged bullets. And that gun belongs to the accused. And it is the very gun which was recovered from the tree. Unless, because it is me who is proving, somebody comes and tells that the uncle and the clan leader are the ones who shot, who discharged the bullets from the gun. And if they are not the ones, that means we shall impact. And I will infer that it is the accused, the gun, for other means of which court will have to deliberate. He further found out that the walls of the firing pin impression on the cartridge cases A1 to 6 and those of the test fired cases from the exhibit D have circular striations that appeared to align. And furthermore, the flowback rings edges are contoured and serrated with microsphere in suggesting possible common origin of the marks and giving his opinion that the cartridge case exhibit 8 to 6 could have been discharged from exhibit rifle D. The laboratory report, my lord, was exhibited as prosecution exhibit number 4. I'm not going to explain much. This is an opinion. It doesn't require any further explanation. But in simple terms, he said that when the gun was presented to him, together with the exhibits, he went and shot other bullets. Then he collected those bullets and compared them with the exhibits he had received, and they were aligning in simple terms. And opinion evidence sometimes is not supposed to be challenged. It's supposed to move the way it is. And I was wondering why my land brother was going ahead to ask the ballistic expert, because he's the former man, meaning that the ballistic expert placed the accused at the scene at Loro Town Council. Because what was collected from the scene and what was collected from the tree, they correspond, saying that those cartridge cases at one time were used by the same group. And I impact that and put it on him that he's the one who was on the motorcycle. And it is a settled law. And it is settled law, my lord, that the burden of proving alibi does not lie on the prisoner who is the accused, beyond reasonable doubt. And in the case of Secretarial versus Uganda, it is the duty of the court to direct its mind properly to any alibi set up by the accused. And it is only when the court comes to a conclusion that the alibi is unsound that it will be entitled, that the court is entitled to reject it. And in the case of Ara versus Thomas Fino, 1916, volume 12, it is a criminal application report at page 27, we found that the accused's defense is consistent of unexplained inconsistencies, which amounted to blatant lies. Emphasis should be put on that authority, my lord. The accused in his defense agreed, having signed the gun and 120 rounds of ammunition for guard duties from the armor of 3 FAR, that is Field Artillery Regiment, one of the units in SFC. And on the 25th day of December, in his own defense, he wrapped the said gun in a mattress and tied it on a motorcycle, red Bajaj, belonging to Private Gonza Julius. And he rode the same up to Dog Pill, his home area, and reached at that home at 11:30 p.m. That is his testimony. He further told the court that the purpose of escaping with the gun was to kill Oyam James, whom he suspected to be having love affairs with his wife. During cross-examination, my lord, he admits having left a magazine and SFC uniform at his home And his home, Your Honor, was not an armorer, was not a UPDF armory. All military equipment which are monopoly for UPDF, including a uniform, is not supposed to be kept in anyone's home whatsoever. Whatsoever, I emphasize on that. And at the time, he was in hiding, armed with a gun and 90 rounds of armors. BW1 father told court during examination in chief that he was just convinced by the clan leader and his uncle Adoko Moses to hand over the gun and its ammunition, and later called them on phone and directed them to a tree where they recovered a gun, and where they directed them to a tree near the Tot River where he had placed the gun, 3 magazines containing 88 bullets, 2 live bullets, and a motorcycle Bajaj red. That was his evidence. And left. And later, he told court that during the examination in chief, that he took the motorcycle to a petrol station to be taken back to the barracks. You can see, my lord, such an inconsistency, and you should underline it. And when I cross-examined him, he started hiding away from my cross-examination because he knew that he was telling lies. And at that juncture is when I made an application of his counsel to declare him that he's a liar so that he can be charged with perjury. And of which it was hard because he was not my witness. He was a witness for the defense. I wish he was mine. Now he could be answering another case of telling lies the Honorable Court. And the conduct, I'm going to talk briefly about the conduct before, at, and immediately after committing the crime. When, my lord, when the offense was committed, when the accused came, was cited, when he was cited within the places of Dog P, and at the same time, in the trading center where he was repairing the motorcycle, it's when the offense of robbery and murder happened. Then immediately, when that offense happened, the accused stayed in motion. He was running right from that day up to the time when he was arrested in Lira City. This is a man who started running away. He was seen running to the maize plantation by PW13 and at the same time shooting. Later, he directed the clan leader that he had placed the gun on the tree. Later, he's telling the Honorable Court that he ran to a petrol station and took the motorcycle. And at the same time, it is his evidence that he was arrested in India, which is not in contradiction, meaning that the accused, my lord, remained in motion and he was on run. That is a conduct of a guilty mind and of which he has no defense at all. And his counsel will submit as why his client was on run. He saw the IO, Captain IO, he did not surrender himself. And there was no case. If he knew that he had not committed the case, why didn't he say, I found him here? Then the captain takes him back. He had a double cabin. He described the double cabin and that he was in the bush. That element of running away, you are showing that you are guilty before even court convicts you. And it is my humble prayer, my Lord, that you convict the accused person in respect to count 1. I have overproved all the ingredients against the accused, unless otherwise. My Lord, at this time, I've already handed count 1 and the last ingredient in the robbery. Now, allow me to proceed with count 2. To constitute the offenses of aggravated robbery, Code of Section 285 and 286(2) of the PCA, The prosecution must prove the following. One, whether there was theft of the property, whether there was violence at, before, and after the theft, and that the accused person caused grievous harm to the complainant, and that the accused was armed with a deadly weapon before, during, and after the theft, and that the accused person participated in the robbery. Now I will omit element number 4 because it has all been exhausted in the first count. Then I will go direct to theft, Your Honor. Theft is defined by section 254(1) of the PCA. It occurs when a person fraudulently and willing to deprive the owner of the thing capable of being stolen takes that thing from the owner without any claim of right. And the thing, Your Honor, in this respect was taken. The accused stole 65 Uganda shillings from Madam Lili Obote. And the 65,000 Uganda shillings is capable of being stolen. And to prove the offense of theft, the prosecution relied on the evidence of PW11, who is Madam Lili Obote, and PW4, who testified that the accused came to the board and stopped on the roadside. He later entered the hard shop while armed with SMG and ordered the shop attendant to put all the money in the shopping bag, and later picked 65,000 money, which was on the counter, and that it was the evidence of my witness that the accused took this money. He cocked the gun twice, and one live bullet got out of the gun and fell down. It was later picked. During the theft of the accused, he was identified by PW11 that he took there the 4 minutes and he was putting on a military uniform. He gave all the description. A female owner of the shop who is aged 64 years cannot be in court to tell lies. In fact, Your Honor, I will bring to your attention that my PW11 is a victim, is the very victim of the robbery. And up to now, that money is in the hands of the accused person. When you are convicting him and sentencing, you should order him to pay that money, in fact, even times 10, to compensate my witness. And to add on, therefore, this proves that there was theft of property from the hardware store belonging to that very victim. With my honor, I move to element number 2, whether there was violence at, before, or after the theft, or that the accused person caused grievous harm to the complainants. The prosecution led evidence against this was that the accused was seen by Boer innocent with a gun, who on a border. And the evidence of PW11 was that the accused entered the hardware shop while armed with AK-47 and put a shop and he was carrying an AK-47 rifle, and it is her evidence that she was put on gunpoint, and she was instructed to hand over the money. And she went ahead to inform the Honorable Court that he cocked twice. The reason as to why the military court will take judicial notice. was assaulted seriously. Accused pointed a gun at him. And he ended up shooting him. And when you look at the photos which presented before the court, you will see that he was shot on the collarbone, and the bullet went and penetrated through the QC. The photos are, you review them properly, Your Honor. They are there for you as prosecution exhibits before the Honorable Court. So the violence meted out to the victims is confirmed by the doctor who attended to them at Nyeke Health Center 4 and found that the victims had sustained gunshot wounds, and the one, Okola Kizito, was unconscious. He claims that he was unconscious at the time when he was taken to the hospital, and the whole body was soaked in blood. All the accused had targeted his left lower abdomen and gluteal through were consistent by the use of violence as demonstrated by all the prosecution witnesses who saw the accused shooting at them. The victims were seriously injured, and PW13, who was the first responder and attended to them, at the scene of crime. He said that blood was all over the floor. And when you look at the photographs, the SOCO presented PW, the last witness, when you look at those photographs, you'll see the blood was all over the floor. And he had time to capture that evidence, and it is our prosecution evidence on a record. Your Honor, to corroborate the above, also a boy innocent, our PW7 was just outside the factory. And also saw this man dressed in a military uniform with a gun, and he was shooting at everyone. That's what they term as careless shooting. And later he had blood oozing on his left side when he realized that he had been shot. Such kind of behaviors must be looked upon, and we impart and we say that all allude to the accused person that is the one who committed those offenses. Now, to come to my conclusion, my Lord, I have a question which I want to set. That my question now, as the prosecutor, before you, Your Honor, remains and still lingering in the minds of the court, that when the accused person escaped from the barracks with a gun and rounds of ammunition to areas of Oyam district, and considering all the circumstances surrounding the commission of the offense and the evidence the eyewitnesses gave before the Honorable Court vis-a-vis the conduct of the accused person after the commission of the offense, my Lord, all allude that the accused committed the said offense, that murder, and that is murder and aggravated robbery. I submit. And in the nutshell, in my conclusion, I still contend that the accused person was ably identified by my witnesses who placed him at the scene. Thus this, it is my humble prayer that my Lord should deliberate in my favor in all counts that the accused committed the said offenses. And therefore, this court be inclined and moved, my Lord, to convict the accused person as charged. I so pray.
Honorable Chairman and honorable members of court. I've heard and followed the submissions of my land colleague, and I hereby exercise the right of the accused under Regulation 61 of the UPDF Rules of Procedure, Statutory Instrument 307-1. I'll start by highlighting the burden of proof in cases such as the one before us. And it's really a cardinal principle of law, as has been re-emphasized and was stated in Wilmington versus DPP 1935 SC, page 462, that the burden of proof in criminal trials lies on the prosecution. This is also highlighted under Section 103 of the Evidence Act, Cap 6, and I quote, "The burden of proof as to any particular fact lies on the person who wishes the court to believe its existence, unless it is proved by law that the proof of that fact lie on any other particular person." So the burden never shifts. And an accused person can only be convicted on the strength of the prosecution case and not on the weakness of their respective defense. This was highlighted in the case of Sechitoreko versus Uganda, East Africa, at page 531. So in criminal matters, the accused does not have an obligation to prove his innocence. It's the prosecution to pin the accused to each and every crime they are charging them with. So the standard of proof was well stated in Miller versus Minister of Pensions, 1947, volume 2, All England Law Reports, at page 372, as proof beyond reasonable doubt. Now, the ingredients of murder, as this is a murder trial, case number 493 of 2015, as the following: that the death of a human being occurred, that the death was caused unlawfully, that death was caused with malice aforethought, and the accused participated in the crime. Throughout the trial, and as the prosecution laid down its case, it truly proved that an incident happened in Loro Town Council on the night of the 26th December, and the death was unlawful, and maybe there was malice. However, they never proved, and what we seek to challenge and do contend is that whoever carried out the actions on that same night was not the person before us today. So I will limit my submissions on the participation of the accused. And this cuts across for both murder and aggravated robbery, since this was a series of events. Now, the ingredients for aggravated robbery were also highlighted in the same case, Uganda versus Sebo Muhammad, cited above. That there was theft, that there was use of violence, that there was a threat to use a deadly weapon, or there was use of a deadly weapon, or that the perpetrators caused grievous harm to the victim. That it is the accused who robbed the victim, and where there is more than one accused, common intention has to also be proved. So the commonality in both counts is the participation of the accused, and that is what we are contending here. So to help court resolve this case, I have adduced a number of issues which I will lay down for court's adjudication. And these are: 1, whether the identification parade was properly conducted in accordance with the laid down principles of law. 2, whether the accused was correctly identified and placed at the scene of crime. And 3, whether the accused participated in the commission of the alleged offenses. I'll handle them chronologically, and I'll start with issue 1, whether the identification parade was properly conducted in accordance with the laid down principles of law. Now, the key eyewitnesses to this murder trial, were a bold innocent prosecution witness number 7, prosecution witness number 8, Private Okello Emmanuel, prosecution witness number 11, Miss Lydia Obote, prosecution witness number 12, Chiza Vincent, and prosecution witness number 13, Orima Justin. Now let me first crystallize on the identification parade. This was conducted, and among the key witnesses that I've just mentioned, only 2 of them were called forth. And these are prosecution witness number 7, Ball Innocent, and prosecution witness number 12, Chiza Vincent. However, our contention is with the circumstances under which the said identification parade was conducted. And it is this that warrants the attention of court. The rules governing identification parades were set forth in the case of Republic versus Mwanga, 1936, East African Court of Appeal, at page 29. And they were also reproduced in Uganda Criminal Justice Bench Book, first edition of 2017. And they are thus: that the accused person is always informed, emphasis on that, always informed, not for him asking, always informed that he or she may have an advocate present when the identification parade is conducted. I had some fanciful interpretations of the law from my land colleague that the accused person has to request. That is not what the law says. The accused person has to be informed. Now, the second requirement is that the officer in charge of the case, although he or she may be present, does not carry out the identification. The third, that the witness does not see the accused person before the parade. The fourth, that the accused person is placed among at least 8 people as far as possible of similar age, height, general appearance, and class of life as him or herself. The fifth, in introducing the witness, tell him or her that they will see a group of people who may or may not contain the suspected person. Do not say, pick out somebody or influence him or her in any way whatsoever. The sixth, that the accused is allowed to take any position he or she wishes after each identifying witness has left, if he or she desires. 7, that care should be exercised that the witness don't communicate with each other after they have been to the parade. 8, that they have to exclude every person who has no business being at the identification parade. 9, that they should make a careful note after each witness leaves the parade, recording whether the witness identifies the accused or any other observation that is of interest. 10, that if the witness desires to see the accused walk, speak, or perform any act or action, all the persons lined up in the parade should be asked to do this. a letter from the witness if he or she is contented with the way the parade has been conducted, and make note of his or her reply. 12, that the officer should make a report of the identification parade and enter a copy on the accused police file. Now the report was made, and this report was tendered in as prosecution exhibit number 6. The prosecution called the officer who conducted the identification parade as prosecution witness number 14, AIP Opel Richard. During cross-examination, he was asked, did you inform the accused of his right to have a lawyer present? To which he replied, no. He was also asked, and court should bear in mind that prosecution exhibit number 6 shows that, because it has a questionnaire of all these conditions which has to be filled. He had answered yes on the questionnaire. So it goes to show that most of what he was saying was untrue, either on the identification report that he made or before court. These are inconsistencies in the prosecution case. This is despite the fact. Now, when further cross-examined, PW14, AIP Opel Richard, was asked on the nature of briefing that was given to the accused. Remember, as stated earlier, in the conditions that have to be fulfilled, and I repeat, it was condition 5. In introducing the witness, tell him or her that they will see a group of people who may or may not contain the suspected person. Don't say pick out somebody or influence him or her in any way whatsoever. PW14, when I posed this question to him, what kind of briefing was given to the witnesses prior to entering or conducting the parade? He simply told us that he told them that the person we want is among the 8. You pick him out. This was wrong. Now, critically, as he gave evidence before the court, he stated that there was a huge crowd, that the people had gathered since morning, and they were there waiting for the accused to be seen, since they were in the know that he was being transported from Serakasenyi Detention Center to Loro Police Station. Key to note as well is that the identification parade and PE prosecution exhibit number 6 shows that the parade was conducted at 14:30 hours. So the people had been there since morning. This gap in the time frame shows that the accused arrived within the same timeline as and found a huge crowd when it was being brought. It leaves the impression that indeed when he was brought, with the protection that surrounded him, parade, this was way before the entire parade was conducted. Remember, the conditions of law, as read above, say that anyone who shouldn't or who doesn't have any business to do with the parade should be excluded. However, this parade was conducted in the open. They made a spectacle out of it. So the witnesses had seen the accused as he was being brought. He was being very well guarded by a number of SFC soldiers. There is no way they could have missed to know that this is the person whom they have brought to conduct this exercise. So they not only infringed on the principle that in order for an identification parade to be properly conducted, the witness must not see the accused prior to the parade. They were literally picking out someone they had already seen. They made a sham out of the entire exercise. 2, what were the crowds doing there? It's also a cardinal principle in the rules of conducting identification parades I've already stated earlier, that those that have no business at the parade should not be available. But everyone was there to see. Interestingly, when you read the report, and I do invite court to look at it with a microscopic lens, very much, many of the conditions are allegedly signed as fulfilled. Leads to impression. Either AIP or Pearl was lying on court, for which, if true, should be adjudged as a witness who is not credible and can be charged with perjury, or the identification report he made was wrong. I'm inclined to believe that the gentleman wouldn't have lied on oath. He told the truth the way he saw it. But the parade report was wrong. I invite court to disregard it as it is untrue to various material facts pertaining to this case. He admitted the parade was conducted outside in full view of the crowd, and also AIP or Pearl Richard reinforced this notion. The infringements made to the principles governing identification parades, as highlighted above, and in my submissions, show that the accused and will have his rights infringed if the parade report conducted in such a manner is accepted. And it also leaves an impression that everyone who stood before this court and testified on that Bible or the Quran and claimed to be an eyewitness wasn't there on that day, the day of the 19th of March 2024, to see this person who they allegedly claim carried out these crimes. So everything else that came after was confirmation bias. They knew, they had seen the person. Even someone who had not seen him clearly, at least now knew that this is a suspect. So it is prudent to note that in the case of Sesanga Stephen versus Uganda, Civil Appeal number 85 of 2000, as quoted authoritatively in Coron Stanley versus Uganda, Criminal Appeal number 314 of 2003, court observed that the right of the accused to be informed that he could have his lawyer present to the entire parade. So whatever was carried out, and I speak this authoritatively, was a sham and should be disregarded. It is a defense submission and assertion that the irregularities in conducting the identification parade above highlighted rendered the entire exercise unfair and unjust and fatally affected its credibility and that of the report that arose from it. I thus invite court to disregard the identification parade report, prosecution exhibit number 6, and also to contemplate on the impression of such irregularities on the eyewitnesses brought before this court, since they mostly saw the accused when he was delivered to Loro police station in the spectacle That became the identification parade exercise. Interestingly, out of all people, now, prosecution witness, but I think I'll get to that later. Let me move ahead to issue number 2. It covers that. Whether the accused was correctly identified and placed at the scene of crime. Now, the legal principles that govern identification in criminal matters was set up in the Locus Classicus case of Moses Bogere versus Uganda, 1998, Uganda Supreme Court at page 22. And I quote, "The starting point is that a court ought to satisfy itself from the evidence whether the conditions under which identification is claimed to have been made were or were not difficult, and to warn itself of the possibility of mistaken identity. The court should then proceed to evaluate the evidence cautiously so that it does not convict or uphold a conviction unless it is satisfied that mistaken identity is ruled out. In so doing, the court must consider the evidence as a whole, namely the evidence, if any, of the factors favoring correct identification, together with those rendering it difficult." Now, it is strike law that no niche of evidence, no iota, no piece of evidence should be weighed except in relation to all the rest of evidence. And this was established in the case of Sulaiman Katushabe versus Uganda, Supreme Court Criminal Appeal number 7 of 1991. Now, what really is the problem with mistaken identity? The problem of cases dependent on identification, such as the one before us today, were highlighted in the case of George William Karyesobula versus Uganda, Criminal Appeal number 16 of 1997. And this is what the court had to say about it. The law with regard to identification has been stated on numerous occasions. The courts have been guided by various cases such as Abdallah bin Wendo and another versus R, 1953, volume 20, East Africa at page 166. And Rodia versus Republic, 1967, East Africa at page 583. To the effect that although a fact can be proved by the testimony of a single witness, this does not lessen the need for testing with greatest care the evidence of such a witness in respect to identification, especially when the conditions favoring correct identification were difficult. In such circumstances, what is needed is other evidence pointing to the guilt from which it can reasonably be concluded that the evidence of identification can safely be accepted as free from the possibility of error. Now, the need for care to be taken when handling cases of identification, as read in the passage above, is not required in respect of a single eyewitness only, but is also necessary even where there are more than one eyewitnesses, where the basic issue is that of identification, such as in the case before us today. And another versus Uganda, Criminal Appeal number 9 of 1978. In the following passage of the judgment, court observed, where the case against an accused person depends wholly or substantially on the correctness of one or more identifications of the accused, which the defense disputes, the judge should warn him The judge should warn himself and the assessors of the special need for caution before convicting the accused in reliance on the correctness of identification or identifications. The reason for this special caution is that there is a possibility that a mistaken witness can be a convincing one, and that even a number of such witnesses can all be mistaken. That possibility is there. The prosecution witnesses that came and testified, there is a possibility that they were all mistaken as to the identity of the person. The judge should then examine closely the circumstances in which the identification came to be made, and the factors for identification are hereby set. 1, the length of time, the person, the distance between you and that person you're observing, the light available, the familiarity of the witness with the accused. Now the crime to which they are, and another versus Uganda. So I will start to scrutinize in light of those factors that I've mentioned. Now I'll start with prosecution witness number 7, a boy innocent. He testified during cross-examination that he saw the accused initially being driven on a border at around 5:30 p.m. wearing the land forces digital military uniform, and that he observed him for merely seconds. These uniforms, to ensure that no mistake is made, were brought before court. People wearing these uniforms were brought before court, and the witnesses pointed to the uniforms that they mean. He also claimed the accused bypassed him just 5 meters. But when asked for how long did you take to observe him, remember the element of the length of time taken. He said merely seconds. When asked, did you know the accused before the night of the 26th? He said, I had last met him long ago. I further pressed, how long ago? I cannot remember. That was his answer. He said the accused came to Loro on a bicycle some time back. So there was no actual familiarity with the accused. He wasn't his friend. He didn't know him. How can we be sure that he recognized a stranger and marked the face? For mere seconds, it doesn't make sense. I further pressed him. Was he wearing a jacket? He said no. On the second encounter, the one where the mayhem started, it was around 7:30, total darkness. He said he observed a man putting on land forces uniform. I asked him, did the man have a jacket on? He said no. However, he said he had camouflaged his face. As to the nature of the camouflage, he didn't tell us. So now let us test his evidence and view it through the factors set in the Abdallah Nabriri case. This was a person who he saw for mere seconds initially, a person who was not familiar to him. The lighting was never mentioned. Judicial notice is taken of the fact that, and should be taken, I invite court to take it, of the fact that 7:30 there is darkness. He stated that the man had camouflaged his face. He also stated that he was fearful, was scared, but then claimed that he clearly identified the accused. It doesn't make sense. How How did he identify him? Interestingly, he never made a statement at police. At least if he did, it was never produced before this court. How do we know that any evidence he gave was not merely an afterthought after he observed the accused being paraded at Loro police station? I will move ahead to prosecution witness number 8, Private Okero Emmanuel. He claims that the assailant had on an SFC multicam uniform. This directly challenges the evidence of a bold innocent who claimed the assailant had on a digital uniform. Now, prosecution witness number 8 claims that upon hearing shots, he rushed out of his mother's shop. Immediately as he rushed out, it was his evidence that his eyes met with those of the accused. The assailant then aimed a gun at him and immediately fired the bullet. Now I want us to consider the sequence of events. The duration of time, because he said everything happened immediately. It was a sequence of events. Hearing shots, rushing out, meets the assailant shoots him. I aver that this sequence of events wouldn't have taken more than 30 seconds. It was his evidence in cross-examination that he was unknown to the accused before the night of 26 December 2023. He didn't know him. They had never met before. How then could he have been sure that it was the person before this court, that it is the person before this court who shot him? He claimed the man had camouflaged himself. He had covered his head, the ears, but you could see the face. In 30 seconds, shots are being fired. There is chaos and mayhem everywhere. It doesn't make sense. 30 seconds. You've never met before. Well, although he actually did state that there was lighting from the shop, he never told us the distance which him and the accused were. What type of lighting was it? How strong was it? These are all questions that the prosecution failed to answer. Now go to PW11, Miss Lady Obote. I don't want to sound uncouth, but counsel made a statement that there's no way a 64-year-old person can lie. We are human beings. We all know that's untrue. Even old men lie. That the good madam was lying. She could have been mistaken. It is human to err. She claimed she identified the assailant as he came in her shop wearing an SFC multicam uniform. That's a very unique and stark observation. So I pressed further in cross-examination and asked her, was he wearing a jacket? She said, yes. And I asked, what type of jacket? What's the color? She said she doesn't know. Now it's quite intriguing. She claimed she had observed him for 4 minutes before he saw her. A one-roomed house, one-roomed shop, which I do thank counsel. It's on court record. The exhibits, I think prosecution exhibit number 9, marked RJ1 and 2, show the entrance of our shop. The size, the estimate she gave of this house were quite modest. It doesn't make sense that a person can stand in a shop such as hers, limited and modest, even this one, even if it was this huge, and take 4 minutes to observe a person who's just seated down there. She also claimed she was scared when the whole ordeal started. When pressed in cross-examination as to the nature, how did you escape? He said, I escaped to the next room. Now this is the same person who had told court initially that it's a one-room shop. So one of the members, of course, challenged her on that. She said, no, I escaped to the compound, further contradicting herself. How sure are we that she's not mistaken the identity of the accused? They were unknown to each other. The timelines she has given, the 4 minutes, it doesn't make sense. How can someone stand in a shop for 4 minutes without observing you? So, inconsistencies are glaring. Find that these inconsistencies, they do kind of point to deliberate untruthfulness and gravely affect the credibility of PW11. So I'll move ahead to PW12, Chiza Vincent. He claimed he knew the accused as his customer since had once repaired his bicycle, which he had last seen, but had last seen him over 5 years ago. 5 years ago. Now, I had some disturbing remarks from my land colleague in which he inventively put words in the witness's mouth that he said he owns a sport bike. He never did. He said he has never owned a bicycle in his life. What he was driving, an old motorcycle that belonged to his grandfather. So how then, what kind of transaction was there? If the witness, DW1, whose evidence, the cogency of it was unmatched, it was logical from point A to point B, even under the scrutiny of the prosecution. He never changed his statement. He said, I've never owned a bicycle. He is a bicycle mechanic, PW12, who claims that has always been my customer. How? If indeed he was his customer, why then? Now another inconsistency that came and resulted from the evidence of PW12 is that he claimed that he saw the assailant vividly. 3 meters, even told me, 3 meters, the one next to you, and was putting on a digital land forces uniform. Whereas this corroborates the evidence of a ball innocent. It is contradictory to the evidence of Miss Lily Obote and that of Private Okello Emmanuel. So who is telling the truth? Who is who? From 3 meters, you cannot be mistaken about attire. From 3 meters. These are all inconsistencies in the prosecution case. So how then can you tell me that you observed a man's face who most of the witnesses claim had it covered? One went to say it was even camouflage. No, Another interesting fact is that during cross-examination, PW12, Mr. Chiza was questioned. How did you identify that indeed it was the accused? He said he called me by my nickname, Nyo. This was an interesting development. So I probed further in cross-examination and asked him, is he the only one who calls you by that name? Because if it was an inside name between friends, at least easily understandable. However, he claimed almost everyone in Loro calls me by that name. So how then do you identify someone by a nickname which almost everyone calls you by? Interestingly, a question was posed to him. Do you have friends who are soldiers at Loro Detach? Say. Now this creates a different theory. Defense witness 1, the accused, when he took the stand, I posed a specific question to him. Do you know someone called Chiza Vicent? He said, no. Do you have any friends in Loro Town Council? He said, no. If he had been lying, the prosecution would have easily summoned one of his friends from Loro to challenge him, to challenge his credibility. But this was not done. Why? Questions. Very many questions in the prosecution case. Interestingly, the account of events of PW 12, Mr. Chiza Vicent, he said he met him on the road. And this is interesting. Judicial notice should be taken of the fact that the Lira Road, even the Oyam Road, they don't have security lights. They don't have street lights. How then could you see that this is the person? The lighting. I take you back to the Abdallah and Abreda case. The lighting was off. How could you see a person and recognize a person who you last saw 5 years ago? I'll answer that one for you. You simply can't. Now, prosecution number 13, Mr. Orima Justin. He stated in his examination in chief, as my land colleague was leading him, tell us the sequence of events, was the question, and he replied, upon hearing shots, he went to his office and closed the door, fearing for his life as he rightly should. And then that was quite intriguing. In cross-examination, I posed the question to him, how then did you observe someone outside with a closed door? He could have said through the windows, for which, as I looked and perused through the exhibits, the office has no window. Maybe I'm mistaken as to which office it is, but it doesn't. He said through the crack of the door. The crack of the door doesn't add up. How wide is this crack? All those are questions the prosecution left unanswered. It points to deliberate untruthfulness. For a case such as a case of murder, where the highest punishment a person can be given is death, why would you lie? The contradictions in his statement and the gaps that were left by the prosecution really do affect the credibility of PW 13. Interestingly still, as I've already stated, none of them made a statement to police. At least none that was adduced on court's record. The records are clear. How then do we know, like I said earlier, that this wasn't an afterthought? That maybe he's the one. He was a little bit short. Maybe. But now that they've got him, and everyone has seen him at Loro police station while conducting the identification parade, oh, that's the one. Now let me go and make a statement. I submit that this is likely what happened. True, there was an incident. True, people died, someone died, and others were assaulted. True, there was a robbery. But this is not. It thus can be deduced from the above discussion that the factors favoring proper identification were never established for any of the key eyewitnesses. It should be noted that the accused, as defense witness 1, gave a narration of events and stated that on the 26th of December 2023, he was in Mutual Trading Center. Which he estimated to be over 30 kilometers away from here. This evidence, the cogency of his statements, as I led him in examination in chief, was never really challenged in post-examination. He answered every question that was given, sticking to the story that he had narrated. And I do submit, on the basis of the case of Bakaire Stephen versus Uganda, criminal appeal number 33 of 2015, in which the Supreme Court decision of James Siwabiri and another versus Uganda, criminal appeal number 5, 1990, court observed an omission or neglect to challenge the evidence in chief on a material or essential point by cross-examination would lead to an inference that the evidence is accepted. Through cross-examination of DW1, nothing really challenged the fact that he was where he said he was. Indeed, he stated that he saw Captain Ayo. The law accepts they would have called the captain and asked him, at 19:00 hours, were you in Wicho town? If indeed he was, or he wasn't, he would have known that the accused is lying. This wasn't done. However, something quite pertinent happened. In the statement earlier on of Captain Ayo as he was being cross-examined, he mentioned that on the night of the 22nd, of the 26th of December 2023, he and other people of the district went to the accused's place, took away his uniforms and the magazine. So we know he was within the vicinity of Wicho at the time. It is his evidence. It is also his evidence by 2200 hours he was in Loro. That is what Captain Ayo said. That upon receiving a phone call, he came to Loro about the incident. So the duration of time within which he went, or he was within the vicinity of the accused's home, matched that of his narration. He saw him, he was scared, and he ran and secured his gun. So I move ahead to issue number 3, whether the accused participated in the commission of the alleged offenses. The short answer to that is no. But I'll go into the long one. Let us scrutinize, let us dissect the events as they transpired. So it is prudent to first consider how the accused became a suspect in the first place. This is the starting point. It was the evidence of PW4, Mr. Ashraf Ajibe, the DSO of Oyam, during cross-examination, that the accused became I asked him, at what point in your investigations after the shooting was the accused made a suspect? He said, immediately. Why? His answer to that was because earlier on, Captain Ayo Ak had approached the district security committee and told them that one of our soldiers had escaped. He had escaped from Waza with a gun and was within Oyam. Something interesting then happened. It was the evidence of prosecution witness number 3, Captain Ayo Ak, that he was tracking the accused at all times. Tracking at all times. And he also gave the evidence that at 13:00 hours, his tracking device showed him that the accused was in Achaba subcounty, the accused village. So they had a precise mode of monitoring the accused movements. When I asked him, did the tracking device ever show you that the accused is in Loro? He said, no. So, a shooting happens. A soldier has been reported to have escaped with a gun. So when the shooting happens, automatically the minds of the investigators went to the accused. I said that this was a disservice to the entire investigation, and it actually derailed it. They limited the scope and made the accused not only the prime suspect, but the only suspect, which was wrong. Everything else that happened from then on was just confirmation bias. They had this in their minds that this is the man. Just started gathering evidence to fit the description. Loro barracks is just close by. But the soldiers there never questioned. Was the state parade texter that questioned? Was the ammunition, were the guns counted? Was the ammunition counted? This was never done. They thought they had their man, and yet they didn't. So, and I want to consider something, still in the narration of events. There was evidence of PW5 Sergeant Oyat James. It was his assertion that the accused confessed to him. Something that came up as quite odd. Interestingly, if indeed the accused confessed to the investigating officer, why didn't he write a statement accepting? Why? A statement is the legal document. If he has confessed to you, why not make him write a statement and put it in writing? It was never done. This leaves one possibility. When the accused was asked about the sequence of events and the narration to Sergeant Oyam, he said I was under coercion. The man told me I'll never see my family again. That was wrong. In cross-examination, the accused went ahead to state that the video you saw, I was being coached on what to say. The video was, as an investigating officer, PW5 knew the right thing to do. He should have done the right thing if indeed the confession, the fact that it wasn't done only points you to one thing. Indeed, the accused's assertion that was being coerced were correct. He also made another quite fanciful remark. He said, the accused confessed to me that he had stolen 19 bullets while on a range exercise in Mwaza. This caught my eye, and I went digging. Interestingly, when PW1, the arms officer of Waza, 3 Artillery Regiment, was questioned in cross-examination, have there ever been incidences of stolen arms and ammunition? He said, no. When PW3, the intelligence officer, Captain Ak Ayo of Tirifa, was questioned in cross-examination, have there ever been incidences of stolen ammunition? He said, no. So who is lying? Drives us back to PW5. Someone is being untruthful. If indeed the accused had access to extra ammunition, the prosecution should have gone out of their way to prove this. But nothing was done. A very huge gap in the prosecution case. So, to sum it all up, this points to grave inconsistencies. First parade, a sham parade, where everyone saw, no statements were taken, except those of the people who had actually seen and conducted the sham parade. After they had seen the identifiers, identification factors were never met. The lighting was off for most of the eyewitnesses. And they already had the impression, because I want to take you a little bit back to PW12, Chiza Vicent. He stated, I even have his number, I saved it. Why didn't you go tomorrow to police and tell them, this is the guy, I have his number? Why didn't they produce it before court? Why didn't you phone and we see the number for execution? Yes. So, this all points to grave inconsistencies in the prosecution storyline. Doesn't make sense. And these are not minor, but major inconsistencies, bordering on deliberate untruthfulness, some of the prosecution witnesses. So in the case of Baluku, Samuel and another versus Uganda, 2018, Uganda Supreme Court, at page 26, the Supreme Court stated that we are aware that in assessing the evidence of a witness and the reliance to be placed upon it, his or her inconsistencies, his or her consistency or inconsistency is a relevant consideration. And I invite court to indulge on this case and really take up what the Supreme Court has said. The inconsistencies, they should be considered in evaluating the weight that should be put on these prosecution witnesses. So, the Supreme Court goes ahead in the case of Serapio Tinkamarire versus Uganda Criminal Appeal number 27 of 1989 and stated as follows. As not every inconsistency will result in the witness testimony being rejected. It is only grave inconsistencies. That is what I was pointing at. Grave inconsistencies. A man is covered. You can't even tell the uniform, giving different stories. No statements, no witness statements were even on record. Doesn't make sense. So I want to get on the issue of the ballistics report. My land colleague questioned my actions in challenging the ballistic expert. The law provides for that. I have the right, as the defense counsel of the accused, to challenge any witness brought before court. And interestingly, I asked the ballistic expert on the phraseology he was using in his report. All throughout the report, words such as possibly, possible common origin, possible, means maybe, appeared to align, appeared. If you want to be definite, you say it aligned. The origin is the same, not appeared to align. Could have been the gun, could have been. The phraseology. So when I asked him about the phraseology in cross-examination, he admitted that indeed there is a margin of error. I further pressed, because then it became interesting to me. I asked him, is it possible that identical impressions are made by firing pins in guns of the same make, model, and type? He said, yes, it's possible. The witnesses that the assailants at the night of the 26th held an SMG-56. Almost every soldier in Uganda holds an SMG-56. Even the ones right outside here. So the margin of error creates the possibility. Yes, maybe the impressions were similar, but they were not identical. They were not. This brings in our mind the fact that it is possible the gun wasn't the one. As I conclude, I remind court to make an observation. I remind court of the observation made by His Lordship, Mr. Wilson Masaru Musene, in Uganda versus Mazinga Yukania, High Court Session number 94 of 2017. That it is known for the accused to prove his innocence. He only needs to call evidence that may raise doubt of his guilt in the mind of court. Any doubt in the prosecution case has to be resolved in favor of the accused person. And it is the defense submission that what we have done as a defense is more than create doubt. We have pointed at grave inconsistencies, starting from the investigation. We have pointed at the confirmation bias. Why was he the only suspect? How comes the guns at the nearest barracks were never checked? There was no roll call. We've pointed at the gaps in the prosecution case. In conclusion, the cardinal principle of criminal law, as espoused by His Lordship Masaru Musene in Uganda versus Mande Wilson, criminal case number 22 of 2017, is that an accused person should be convicted on the strength of the case as proved by the prosecution, but not on the weakness of his defense. We first aver that the prosecution has failed to prove an essential ingredient of the two counts of murder and aggravated robbery. This is our assertion. He has failed to prove the participation of the accused. They haven't done that at all. At all. We also invite courts to find that due to the glaring inconsistencies among the prosecution witnesses, the procedural errors in the prosecution evidence, the identification report, the prosecution has guilt to the required standard published in Mira versus Minister of Pensions, 1947, Volume 2, All England Law Reports, at page 372. We first pray that this court finds the accused not guilty on all counts. I do so.
I'm not going to reply. I'll waive that right. May it please this honorable court. I now move court under Rule 63, 1, paragraph A, with the UPDF Rule of Procedures, SI 301, 307, 1. It requires the judge advocate sum up the evidence and advise court on the road relating to the case in open court. The accused person, RA 2392, Private HU Julius, a male adult soldier of SFC, of UPDF SFC, 3 Fidatira Regiment, Waza, resident of Waza Barracks, Nakaseki District. It's the case of the prosecution that on the 20th day of December 2023, the accused signed a weapon with SMG 56 -61 01 219 to go for guard duties. Instead, he traveled to Oyam district with the same weapon without authority. It should be noted that for any soldier to move from one point to another, he or she must be with authority. On that day, the soldier left his unit without authority. It's the case of the prosecution that of the soldier amounted to offenses. Count 1, murder, and count 2, aggravated robbery.
which took place in Oyam Town Council. The accused when arraigned before this honorable court on the two counts pleaded not guilty on count 1 and count 2. And it's the duty of the state to arraign witnesses to prove the case against the accused. Under Section 103 of the Evidence Act, Part 6, is provided that the burden of proof as to any particular fact lies on that person who wishes court to believe its existence unless it's provided by law that the proof of fact lies on any particular person. This was emphasized in Washington versus DPP 1935 ASC at 462. That's the duty of the prosecution to prove the accused guilty beyond reasonable doubt. The burden of proof does not shift to the accused person. The burden of proof doesn't shift, and the accused cannot be convicted on the strength of the prosecution case, and not because of not on the witness in the defense's case. The standard of proof required in criminal cases is proof beyond reasonable doubt, as discussed in the case of Miller versus Minister of Operations, 1947, 2 All England reports. It's thus the duty of this court to establish whether the state only executed its duty or burden in proving the case against the accused person, and on the required standard, which is beyond reasonable doubt. And here, court shall look at the various ingredients of the offenses. Count 1, murder, under Section 188 and 189. The ingredients of murder were highlighted in the case of Uganda versus Mchunguzi, Godfrey, High Court Criminal Appeal, 01 at page 332 of the accused disagrees with the fact that he participated in the commissioning of the offense. It's thus the duty of the state to spare the place the accused at the scene of crime, wherefrom, if he's put at the scene of crime, the accused will be convicted. And to the contrary, this honorable court should acquit him in respect of count 1. He be set free and acquitted due to the failure of the state to place him at the scene of crime. In respect of count 2, aggravated robbery under Section 285 and 286, subsection 2 of the Penal Code Act, Cap 120. The ingredients were highlighted in the case of Uganda versus Ivan and 3 others. It's a 2002 case. That there was safety. This honorable court will look, 1, for the fact that whether or not there was theft of property. 2, court will establish whether there was use of actual force at, before or after the theft, or that the accused person caused grievous harm to the complainant or victims. Then C, this honorable court should also assess and evaluate whether the assailant or the accused person during or after the theft. And lastly, this honorable court should establish whether the accused person participated in the robbery. Under ingredient 1, 50 theft occurs when a person fraudulently and with intent to deprive the owner of a thing capable of being stolen, takes that thing from the owner without claim of right. In the instant case, it's alleged that the state alleges that the accused person robbed 1 million obote, shilling amounting to 65,000 shillings. So court should assess whether that the 65,000 shillings is a property belonging to somebody which was taken away from her fraudulently and whether it's capable of being stolen. If 65,000 is a property defeating those ingredients, then that ingredient shall have been fulfilled by the state. So once there is a subtraction of the property that takes place without consent of the owner, then there is safety. So that's what this honorable court should look at. Then under ingredient 2, the prosecution evidence must prove that the accused, the victims, were physically assaulted and the person or persons sustained grievous harm on his or her body. It's alleged that a few people were armed and 1 person died in the circumstances. So this is up to this court to assess whether really there was grievous bodily harm occasioned to any person, whether it was fatal or not, as long as there was anything grievous on any person, then that ingredient will be proved. So courts should also look at the weapon used, whether it was capable of causing harm or not. If that weapon was not capable of causing harm, then then that ingredient cannot stand. And to the contrary, if that weapon is capable of causing harm, this ingredient will stand. And in the instant case, in the case of the prosecution alleges that the said weapon was used. So, court should take judicial notice that a gun is a killer weapon. So now it's up to the court to reconnect the accused person to the weapon. If it's positive, then this ingredient shall have been proved. The accused participation is the other count. The accused participation in the robbery. In determining the issue of participation, courts must examine all evidence closely bearing in mind the established general rule that an accused person doesn't have to prove his innocence. It's not his duty to prove his innocence. Whether he has a lawyer or not, whether he keeps quiet or what, it's not his duty to prove his innocence. The burden is on the state. And by putting forward a defense of alibi or any other, an accused person does not thereby assume the burden of proving the defense in a few exceptional cases provided by the law. So in general, it's not his role to prove that he was innocent. The burden fairly lies on the state. So that's what we'll have to assess and see whether really the state will be his case or not. Despite the fact that the accused person raised the defense of alibi. So whether the defense is there or not, it does not shift that burden from the state. It remains the duty of the prosecution to disprove the defense of the accused person by adducing evidence that shows that despite the defense, the offense was committed by the accused person. Whether we disregard the defense or not, the evidence should be enough and overwhelming enough to pin the accused person. If it's to the contrary, then the accused person should be acquitted. The established principles with regard to identification evidence. These were laid down in the case of Abdallah Nabudebe and another versus Uganda. Criminal Appeal number 9 of 1979, where a court stated that the judge should then examine closely the circumstances in which the identification came to be made, particularly the length of time the accused was under observation, the distance, the light, the familiarity of the witnesses with the accused. All these factors go to the quality of the identification evidence. So court should assess whether the prosecution witnesses who testified before here were in position to identify the accused person and were able to place him at the scene of crime, respectively, on both counts, on murder as well as robbery. Then the accused person raised the defense of alibi, that he was at Mitchell, you'll excuse me for the pronunciation, that he was at Mitchell Trading Center, not Loro Town Council, at the time of the commission of the alleged offense. And still it remains the duty of the state to place the accused person from Mitchell and connect him to Loro Town Council, where the incidents took place. And by doing so, he will be disproving the alibi. If the evidence on record was able to disprove the evidence of alibi, then this court should proceed and convict the accused person. And to the contrary, if the evidence on record by the state doesn't disprove the offense of alibi, then the accused person should be acquitted forthwith. However, in the case of Chemoroj Wero Orango, 1937, volume 4, East Yaka, at page 46, court stated that the burden on the person setting up the defense of alibi is to count for some much of the time of the transaction in question as to render it impossible as to have committed the imputed crime. This court it was the duty of the accused person through his lawyer to account for other time. Where was he at that particular time? At the time when the offense was committed. So court will assess what is on record and find out where the accused person was, and assess whether at that particular time he was at the scene of crime. If he was at the scene of crime, then the prosecution shall have proved its case. And to the contrary, if he wasn't at the scene of crime, as he alleges that he was in Ucho, court should acquit the accused forthwith. Then the other ingredient is the use of actual violence before or after the theft or that the accused person caused grievous bodily harm. Court shall evaluate what is on record, what the state is alleging. We saw the witnesses who came here who testified. Some were fired at, somebody died. So court should look at those particular factors and weigh and evaluate and come up with a sentence and come up with a finding, whether there was force and whether there was grievous bodily harm. If it's the contrary, if it wasn't there, then it should be acquitted. If really there was force used, there was a deadly weapon used, and there was bodily harm, physical bodily harm, grievous bodily harm, then the court should proceed and convict the accused accordingly. Courts should also be guided on the issue of identification parade. We had PW15 who conducted the identification parade, AIP Opero. The rules governing the identification parade should be conducted. The rules governing how identification parade should be conducted were enunciated in R versus Mango, son of Mana, 1938, 3 Yaka, at page 29. And it was emphasized in Centre versus Uganda, 1968, East Africa, at page 30, at page 365, and later in Stephen Mugume versus Uganda Criminal Appeal number 20 of 1995. It's the Supreme Court appeal. And they are, so court will look at the following rules and evaluate and see whether really the identification parade was followed the law or not. If they really followed the law, then should proceed and allow the identification parade. And to the contrary, if the laws were not followed, this honorable court should not honor or allow the identification, the testimony in relation to the identification parade. Rule number 1, that the accused person, the accused person should be informed that he may have a solicitor or an advocate or a friend. He may have an advocate or a friend present when the parade takes place. Honorable court members were here, and they will assess whether that rule was followed or not. 2, the office in charge of the case, though he may be present, does not carry out the identification parade. The officer in charge, in the present case, the officer in charge was Mwangu. So this honorable court should assess whether he took part. The law allows him to be present. He may be present, but he doesn't take part. He doesn't take part in the identification. That is Mufumba. Rule number 3 is that the witness does not see the accused before the parade. Then rule number 4, court should take note of rule number 4, that the accused is placed among at least 8 persons as far as possible of similar age, height, general appearance, class of life, as himself or herself. Then rule number 4, that the accused is allowed to take any position he chose, and that he is allowed to change his position after each identifying witness has left, if he so wishes. Then care should be exercised that the witnesses are not allowed to communicate with each other. Should not communicate with each other after they have been at the identification at the parade. Court will also take note of rule number 7 to exclude every person who has no business at the parade. Then rule number 8, make a careful note after each witness leaves the parade, recording whether the witness identifies or other circumstances. So it's up to the court to assess whether AIP Epero, Richard, followed all those procedures. Then rule number 9 is that the witness desires to see, that if the witness desires to see the accused walk, hear him speak, see him with his hat on or off, see that the officer has to see that that is done. But fortunately, that was not done in the current, so it doesn't apply. As a precautionary measure, it suggests that the whole parade has to do so. Where it's necessary that the above are done, the above acts are done, as a precautionary measure, all the parade has to do so. So it should not identify the accused person only to do so. So it should be uniform. Then the officer should also see that the witness touches the person he identifies. That is rule number 10. Rule number 11, at the termination of the parade or during the parade, ask the accused if he is satisfied that the parade is being conducted in a fair manner and make a note of his reply. Then the officer is also supposed that in introducing the witness, tell him that he will see a group of people who may or may not contain the suspected person. Don't say, pick out somebody or influence him in any way whatsoever. Then lastly, the officer should act with Crosshairs fairness Otherwise, the value of identification as evidence will depreciate, will be depreciated considerably. So it's now the duty of the Honorable Court to assess whether the identification parade followed the laid down principles. If the laid down principles were followed in affirmative, this Honorable Court should honor and allow the testimonies relating to identification parade. And to the contrary, if they were not followed, the above rules should be observed by every police officer conducting an identification parade. Similarly, if it finds that the prosecution proved all the evidence of aggravated robbery beyond reasonable doubt, then the court shall proceed and convict the accused person and put him on his mitigation. In the same vein, if the court finds that the prosecution proved all the evidence of murder, according to section 188 and 189, this Honorable Court should proceed and convict the accused person and put him on his own mitigation. This Honorable Court should also look into the factors such as the circumstantial evidence. This case has a lot of interesting matters. So court should also look at other circumstantial evidence and weigh in whether they may be of value, they have any evidential value to this matter. If other circumstantial evidence are of evidential value, this Honorable Court should take note of the same in coming up whether the accused will be convicted or not. Court is also under duty to look into the contradictions as raised by the state, by the defense, the various contradictions as raised by the state and the reply by as raised by the state. Then, finally, if the state establishes that if the court establishes that the prosecution has established a case, has proved all the evidence in respect of count 1 beyond reasonable doubt, then the accused person should be convicted. And the same applies to count 2. If the wisdom of this Honorable Court that the state has produced all the necessary evidence and proven its case beyond reasonable doubt in respect of count 2, this Honorable Court should proceed and convict the accused person and put him on his own mitigation. Under Rule 63, Sub-Rule 2 of the UPDF Rules of Procedure, when the court is deliberating, no one shall be present except the chairman and the court members. It's in my hand prayer that this court closes to deliberate on this matter and thereafter come up with its findings and pronounce them in open court. I so pray.
court findings on final submissions by the state and the defense. This court keenly evaluated, assessed, and examined the final submissions of both the prosecution and the defense counsel, as well as the legal guidance from the judge advocate. This court therefore finds as follows. Count 1, murder, contract section 188 and 189 of the Penal Code Act, chapter 120. 1, that there was death of a human being, 1 Okola Isaac Kizito. 2, that death was unlawfully caused. 3, that death was caused with malice aforethought. The prosecutor ably presented on the above ingredients, and the defense has no contestation on the trial. The defense, however, contests the fourth ingredient, that is, the accused participated in causing the death of 1 Okola Isaac Kizito. The defense raised the defense of alibi. The testimonies of PW7, Mr. Ebol Innocent, PW11, Mrs. Lile Obote, PW12, Mr. Chiza Vincent, and PW13, Mr. Olima Justin, were able to identify the accused at the scene of crime. In view of the above, this court finds that the prosecution has discharged its burden of disapproving the alibi raised and rightly placed the accused at the scene of crime, and hereby convict the accused and put him on mitigation. In respect of count 2, aggravated robbery, which is contrary to section 285 and 286 of the Penal Code Act, chapter 120, court examined, evaluated, and assessed the evidence in regard to A, that there was theft of property. Under section 254, subsection 1 of the Penal Code Act, chapter 120, theft occurs when a person fraudulently and with intent to deprive the owner of a thing capable of being stolen, takes that thing from the owner without a claim of right. Accordingly, according to the evidence of PW11, Mrs. Lile Obote, she confirmed to this court that money worth Uganda shillings stolen by the accused. Use of actual violence at, before, or after the theft, or that the accused person caused grievous harm to the complainant or to the victim. Court established that there was violence on PW11, Mrs. Lile Obote, when she was ordered by the accused to put the money in the black polythene bag that he came along with in his pocket. The court further established that immediately after robbery, the accused caused grievous harm on PW8 Private Okero Emmanuel, who was shot at the collarbone and he sustained injuries. He went ahead and attacked the milling factory, where he shot and injured PW7, a born innocent, who sustained bullet injuries on the left upper thigh. Whether the assailant was armed with a deadly weapon before or after the theft. Court established that the accused in his own testimony had signed his gun SMG to wit number 56-610-1219 with 120 rounds of ammunition, and he was in possession of the same until it was recovered. The same was confirmed by PW11, Mrs. Lile Obote, PW1, the arms officer, Private Ecom Silva, the clan's leader, PW10, Mr. Okuni Richard, and PW4, the ballistic expert, Mr. Stephen Samuel Chivuka, who examined the weapon. Whether the accused participated in the robbery. Court established that the accused indeed participated in the robbery as per the testimonies of PW11, Mrs. Lile Obote, who confirmed to court that she saw the accused standing in front of her shop, and later on, she was forced to put all the money that she had in the black polythene bag that the accused pulled out of his pocket. It was the testimony of PW7, Mr. Ebor Innocent, who during examination in chief confirmed to court that he saw the accused, who passed nearby him while at Boda Boda stage at Loro Town Council prior to the incident. PW8 Private Okero Emmanuel Atepo was shot at by the accused. PW12 Mr. Chiza Vincent also confirmed that the accused participated in the shooting and in the robbery. Having considered the prosecution and defense in total, we find that the offense of aggravated robbery has been proved beyond reasonable doubt, and hereby convict the accused person as charged and put him on mitigation. Alibi. The testimonies of PW7, Mr. Ebor Innocent, PW11, Mrs. Lile Obote, PW12, Mr. Chiza Vincent, and PW13, Mr. Olima Justin, were able to identify the accused at the scene of crime. The accused was ably identified in the identification parade as one who was at the scene of crime in Loro Town Council. Circumstantial evidence. The accused is a soldier of UPDF attached to Special Forces Command, deployed at 3 Field Artillery Regiment headquarters at Waza in Nakaseke district. On 25th day of December 2023, he signed his personal weapon to wit SMG 56610 1219 with 120 rounds to go for guard duties. In his own testimony, he stated that he wrapped the gun in the mattress and the magazines in the backpack using the motorcycle he had borrowed from prosecution witness number 2, Private Gonza Julius. And he traveled to Oyam district, proceeded to his home village at Dogopi, Achaba subcounty. His intention of traveling with the weapon was to kill one Mr. Awani James, whom he suspected to be in love affair with his wife, one Miss Akulo Winnie, as per his own testimony during examination in chief. In his own testimony, the accused confirmed that he arrived in Oyam district with his weapon on 25th December 2023 at around 2330 hours, that is 11:30 p.m., and he was in that locality up 28th December 2023 when he was arrested by the security operatives, that is flying squad. And it is during this period that the said criminal offenses were committed. It was during this same period that there was no any other criminal offenses of the same nature that were reported in Oyam district. The identification parade. This court has established that the police officer who conducted the exercise had a requisite rank to conduct an identification parade. The officer in charge of investigation, PW 15, Police Constable Mufumba Powell, though he was on ground, he never participated anywhere in the exercise, and exhibits were not objected to by the defense. The exercise was conducted within police premises. The accused was paraded with 8 volunteers of the same size, height, complexion, and dressed in the same military attire. Therefore, court finds that the accused was properly identified and the set rules were clearly and properly followed. Contradictions. Court considered the contradictions in the prosecution case of both murder, contrary to section 188 and 189 of the Penal Code Act, Chapter 120, and aggravated robbery, contrary to section to conduct section 285 and 286 of the Penal Code Act, Chapter 120, and found that they do not go to the roots of the cases. Whether the incident happened at Loro Town Council or Wicho Trading Center are not major contradictions, given that the accused had a motorbike which could enable him move from one place to another at any given time. He could easily move from Wicho to Loro Town Council and vice versa with the said motorcycle. Accordingly, as earlier established, this court established that the state proved its case beyond reasonable doubt on count 1, which is murder, contrary to section 188 and 189 of the Penal Code Act, Chapter 120, and this court hereby convicts you, RA 239288, Private S. Julius, and put you on your own mitigation. Equal on count 2, aggravated robbery, contrary to section 285 and 286, subsection 2 of the Penal Code Act, chapter. This court has established that the state proved its case beyond reasonable doubt and hereby put you on your own mitigation. We so order.
Much obliged, Your Honor.
Much obliged. Honorable Chairman and honorable members of court, I now proceed under Rule 69 of the UPDF Rules of Procedure, Regulation Statutory Instrument 307-1. Honorable Chairman, the accused now turned convict is 27 years old. He's still young and youthful and can still be resourceful to the nation in a few years. He's married traditionally with a wife, one child aged 4 years. And the wife is also expectant. She's pregnant. He had told me she's probably in her 7th month. So he's a family man with responsibilities. Whereas the crimes with which he has been convicted are indeed grave, I feel the need to point out in mitigation of his circumstances that even when these crimes were committed, there was no premeditation to kill the victim. He's a first-time offender with no priors and no subsisting matters before this or any other court. And it was also part of the prosecution evidence from PW3, the intelligence officer 3FA, artillery regiment, that the accused was a disciplined soldier prior to this incident. Additionally, PW10, the clan leader, also gave evidence stating that the accused growing up and up to this incident, he has been a person that the village had no problems with. It is on the basis of the above stated factors that I beseech court and pray that leniency be shown and that a moderate sentence be handed down. I do so pray.
Honorable member and the chairman of this court, I have a duty to reply to the mitigating factors raised by counsel for the convict. I will first agree that the convict before the honorable court is a first offender because I don't have any matter pending against him. But the court will take recognition that from the time when we started trying the accused person, who is now a convict, has spent resources in trying the matter against the accused person, right from the trial up to the time he's convicted. And also court will take recognition that the accused, who is a convict, is a member of Uganda People's Defense Forces attached to 3FA, that is the Artillery Regiment of Special Forces Command. Your Honor, you'll agree with the prosecution that the soldier escaped from the barracks with a gun loaded with ammunition, 120. He had created the intention of doing an unlawful act, and of which, when he was intermitting to court, he's a trained soldier at his level, and he ought to have known that escaping with a gun is a very serious offense. He did not stop there, Your Honor. He went ahead and caused a robbery in an area of Loro, and which is neighboring just 9 to 10 kilometers away from his home, meaning that he has committed this offense against the public and the community which you are seeing behind, which is within the premises of this honorable court, is annoyed with our member of UPDF. Your Honor, I'll take you back to Article 208 of the Constitution and Article 209 of the Constitution of the Republic of Uganda, and Article 208, Clause 2, provides that the Uganda People's Defense Forces shall be non-partisan, national in character, patriotic, professional, disciplined, productive, and subordinate to the civilian authority as established under this Constitution. Your Honor, he has breached, and this breach goes to the root of the UPDF. He breached the contract because I'll add that he's also a guard, the presidential guard. He's supposed to guard the President of the Republic of Uganda. The reason is why the army trained him to that level. Therefore, if, for example, such an accused person who is a convict before Your Honor fails to guard the civilian and their properties, and at the same time, now will he guard the President of the Republic of Uganda? Now, Your Honor, that contract and the trust has been breached at this level. Your Honor, you'll agree with the prosecution that the offenses under which the accused is charged with are grave in nature. One is murder, and another offense is aggravated robbery. Your Honor, these offenses are on alarming increase, and it is the duty of the UPDF. We should use our crime-fighting techniques to control such offenses effectively. Your Honor, you'll agree that the convict terminated the life of an innocent party, who is Okulo Isaac Kizito, and the bereaved family is here, and Okulo had a wife, a young wife. He himself is aged 19 years. He had a lot to do for the government and for himself, together with the family. He left a young lady with a kid of 8 months, and now the kid is helpless together with the wife. And the family itself is in total psychological torture for having lost their loved ones, and a young boy, a young man who was able to develop the family is unreplaceable. And all that we impacted on the accused, who is a convict. And he did not stop there, Your Honor. He injured a fellow soldier from Nakasongola cantonment, and the soldier now is lame. He got some partial incapacitation, and he never served the UPDF effectively. So he's likely not to work effectively again in the forces because he broke his collarbone. Now he cannot train, cannot undergo any further training. Therefore, he's likely to remain a private by rank, and all that is hampered by the actions of the convict. And there is another gentleman, Obol Emmanuel Innocent. He's also limping and incapacitated. Was incapacitated by the actions of the convict. He shot him on the left thigh, and as of now, he's limping. And the doctors intimated to the prosecution that he's likely to remain incapacitated for life. He was a border, earning a living by riding his border, and he cannot ride that border anymore. He's not educated. He's a man, he's a businessman who was trying to lift his life on himself. Therefore, now he doesn't have any chance of developing himself anymore. He's also married. Now his family has been intimating to me he's in a total loss. The purpose, Your Honor, of sentencing, I do reiterate to the Honorable Court, is to denouncing unlawful conduct. Such a conduct of moving with a weapon without authority, right from Waza barracks up to Dogopio, where he came at his home area without authority. And I will intimate to court that during that season, it was a Christmas season, and UPDF, the entire UPDF was on standby class 1. So all officers, they are accused from committing the same offense, and others who will learn from him will never do the same mistake. And another factor, another purpose which this court is moved to do is to separate the convict from the society where necessary. He has 2 places where he stays. He's an army who stays in Waza barracks, and at the same time, he owns a home around Dogupi. My Lord, it is my humble request that you pass a punishment which will separate him from the army and at the same time from the society of Loro, because the civilians are not happy with his actions. That punishment must be very heavy and grave in nature. Then you also provide a repatriation of harm done to the civilian and the community. That one, he injured the civilians, and at the same time, the community is as well injured. I was informed that the community only started working in March when they saw UPDF officers returning back the convict for identification parade. All along, they used not to work, fearing that army is likely to continue attacking them. Your Honor, now, at this time, I need to tell the accused that the long arm of the law is larger. I repeat that the long arm of the law is larger. Let a message go to the public, because I've seen the medias are here, that this type of conduct must cease, and it will only be seized when the court is passing a deterrent sentence. Your Honor, there is a message. The message I'm passing is similar to the biblical message, where it was quoted that the axe is now ready to cut down the trees. Every tree that does not produce good fruits will be cut down and thrown into fire. The accused committed these crimes while he was in possession of a deadly weapon. My Lord, you take note that during Christmas season, I quote again, we were on standby class 1, and no one was supposed to move. But for him, he decided to commit the offense himself. With that, Your Honor, it is my humble prayer that the deterrent sentence have been meaning for only for the offenses of murder and aggravated robbery. If I'm inclined, it must be death. I so pray.
Honorable Court. This Honorable Court has had the mitigation as ably presented by both counsel, both for the state and the defense. It's now my duty to guide court on the sentencing guidelines, so that court may come up with the most appropriate sentence in the circumstances. The offense of murder, contrary to section 188 and 189 of the Penal Code Act Cap 120, carries the maximum sentence of death. Whereas aggravated robbery, contrary to section 188 and 285 and 285 subsection 2 of the Penal Code Act, carries the maximum sentence of life imprisonment. This court has ably listened to the mitigating factors of both the state, of both the defense counsel and the prosecutor. In his mitigation, the defense asserts that the convict is 27 years old, is a happily married man with one kid and an expecting mother. He has no prayer. His antecedents, as far as I know, there are no worries, and the accused has been a good citizen, and the state prays for leniency, among other factors. To the defense, to the state, he concurs that he's a first offender. However, the state asserts that the convict has pleaded not guilty It's not an assertion. The convict has pleaded not guilty, rather. Has pleaded not guilty. He has caused the integrity of Uganda, beg your pardon, to engage in productive activities for the development of Uganda, to foster harmony and understanding between the defense forces and civilians, this is the cardinal duty of him being a person in uniform. The state asserts that he breached his duty under paragraph C when he terminated the life of one Okora Isaac Chizito and harmed other civilians, not to mention his fellow soldier. So he breached his duty in doing so. Thus, the state prayed for a custodial and deterrent sentence. However, sentencing is guided by the constitutional sentencing guidelines for courts of judicature, practicing direction 2013. Regulation 5 of the same stipulates that the purpose of sentencing being to promote respect for law in order to maintain a just, peaceful, and safe society and promote initiatives to prevent crimes. And this is why we're here. We're here to promote rule of law. We're here to promote justice. We are here to promote peaceful and safe society. That is the essence of sentencing. So as the court members will be deliberating on the sentencing, that shall be the essence of sentencing. Under Regulation 13, court may, before imposing a sentence or during sentencing, the sentencing hearing, ask the offender and the prosecutor to indicate to the courts the appropriate sentencing circumstances. The accused person, through his lawyer, he has prayed for leniency. And to the contrary, the state prayed for deterrence. But at the end of the day, it's up to court to assess and come up with the most appropriate sentence in the circumstances. Regulation 55 and 60 provides for the duties of the prosecution and the defense counsel, respectively, while sentencing, to which they have duly executed their duties to the maximum. Article 28 of the 1995 Constitution provides that the period spent into actual custody during remand must be put into consideration while deliberating on the sentence. Counsel for the accused has not indicated to us the period spent in actual custody. Three months and 19 days. So the 3 months and 19 days shall be put into consideration while deliberating on the sentence. Under Regulation 16, every custodial sentence shall be effective from the date of conviction. So if this court so deems it fit to award as a custodial sentence, shall be effective from today. The third schedule to the sentencing guidelines provides guidance on sentencing ranges on capital offenses, of which the convict is being charged with. Count 1, murder. Contra Section 188 and 189 of the Penal Code Act, Cap 120. The maximum sentence of murder is death. The starting point is 35 years. The appropriate sentence to be determined after taking into account the factors aggravating or mitigating the factors. In each case, is from 35 years up to death. Count 2, aggravated robbery contra Section 285 and 286, subsection 2 of the Penal Code Act, Cap 120. The maximum sentence is life. Beg your pardon, the maximum sentence is death. The starting point is 35 years. The appropriate sentence from 30 years up to death. Those are the sentencing guidelines. It's now my humble prayer that this honorable court crosses and deliberates on the sentence and come up with the most appropriate sentence and thereafter pronounce their findings there, pronounce the same sentence in open court. I so pray.
Listen to your sentence pronouncement. Sentence pronouncement for the convict. RA 239288, Private H. Julius. The convict before this court pleaded guilty, pleaded not guilty to the offenses of count 1, murder, contrary to section 188 and 189 of the Penal Code Act, chapter 120. Count 2, aggravated robbery, contrary to section 285 and 286, subsection 2 of the Penal Code Act, chapter 120. And the court convicted him on its finding of guilty. This court equally directed itself to the mitigation adduced to it by the counsel of the convict. This court notes that the offenses committed are of a serious nature, and there is a need to deter other officers and militants from committing the same offenses. On the other hand, court has taken into account the mitigation by the defense counsel and does consider them in sentencing. In the circumstances, this court considered the 3 months and 9 days and 19 days spent on remand in actual custody. This court therefore sentences you, RA 239288, Private H. Julius, to count 1, life imprisonment at Rosira Government Prison. Count 2, 40 years imprisonment at Rosira Government Prison, and all sentences to run concurrently with effect from today, 17th of April 2024, the date of conviction. You have a right of appeal within 14 days from today if you are not satisfied with the decision of this court. This pronouncement is made in open and public court, and accordingly, this case file is hereby concluded and closed with so order. Given under my hand and seal of this court, this day, 17th of April 2024, on Wednesday, signed by the chairman.
Much obliged, Your Honor.
Much obliged.
So a chan teacher me ngol court. So court me ngol jote read get bear. Win joti out kere joti ako. So nama me mon le tie RA 23. Okay, Pierre Wadek, Pierre Wena Rio, Pierre Boru Boru. Rang me mon ti private, Loni Church, Julius. So what ya koboni a daughter me more com nyona dora me more com Church, no bera dora Rio. E ka daughter adora do ya ente kwer koni ngo. Kar me upenya nyim court ente kwer koni pe ti mo ballo. So bal ma chiel ber balenek. Ame pero ate na ma chek mia chiel Pierre Boru ya Boru ker mia chiel Pierre ka chek kame ulwone Penal Code Act Cap 120. Eka bal me rio ber bal me yak. Ede dogo nyo kere gero nyo gino ke kena me ron wano kwa dano. So bal dang pero ate chek me na ma mia rie Pierre kwanye piru pi bala eno timo. Ame en lawyer merne o tiare nyim court kan. So korno ne bale arione dojo. Ichane tie oberu bale rajo. Ame mera joka nyone giro ko yakina moñ. Whether ngata ti ofida nyo ngata ti adarang. Me noyo kuritimo bale no eno. Itungo kene dan koro puro winyo ngo kogo a lawyer a balla dong tiu chu nyi muni dang gente te ngo gente ne ni chame tuwe nyo chame tuwe le mer jeme do ket ngo ket bet bagina pier tek e ka dwera de kere ni na par bo ngena meno tiego riman nyo no tiego kana no jo tiego ke ye do jo dang ngo koru neno ne pier tek so e chame ngo lo kob da mer ngo mer nen bagina pier tek nyo wel buj kita ngole duj mer considering dwera de kere ni na par bo ngene dujo so don kor utweo RA Pierre Wadek Pierre bo ngene werio Pedega Pierbor we boro private rangeme monye Church Julius. Pibalna machiel ame obero nek Loro ilozira government prison. So balna mario otwe pimwaka nyone pimwaka pierangwen dojo atiek kerlo zira. So twe chien duju awot kara chiel pena tieko mwaka pierangwen nyote donyo doki pie kuona Loro so retin ni dwa para bero medwe mangwen mwaka tumia rio pierewe ngwen tin ni no metwe chako kwano tin. So abale tikere twero metima pel ineno ame pekaro nina para ngwen kanwoni tweche me kor twene pe yenkere. So no miaran wor tema pel ame nina para ngwen po karo. So moga me kote dang ubino kobo kana lera me jo dochia winyo no jo dochia neno and dokote kobo ne kito me kobo toy nyo ngol me kote jo dochie peda ko kobo kana me jo kana ye. So kes file dang jo check ko dang adit chairman na me lo kote me ne beruni itwer mere kope dong gingo kope ende kere twero mero giro ko igiro kope ko. So ena okobone iketo chie kere silen me kote na wuti nenane ikom bala meno utwe kere dano ne. So tien ne dwa para bero duma ngwen mwaka tutumia rio pia rio ngwen. So kar kop tiugi kitu ngola me koti ene na kwani uni poyo.
Your Honor, that is the, I cannot add.
Alright, Baratek, we need to Karashel Krejoto following wa YouTube channel wa Maradu QFM. Itini ni chiadek ni mwa parbor medwe me angwen mwaka tutumia repira rio wi angwen boro nino ame ngala tira binukatu yume court moin man division court marshal of the 01 special force command ame lieutenant colonel Moses Nabasa NML tell you katukiri ngala kom private man Echel Julius ame adot ngoti komene ndo piari wa bishel medwe ma pare mo hatutumi rio piari wa dek en binu chielo na neko Isaac Okola karasiel kere jo ario kenta wa giret me bere private ukele Manuel kere Innocent Ibwal ingola manna me bere atie i Loro subcounty i Loro town council ubinu miyo puod mekwa buch mekwa Loro iwi Echel ame bere dan me mo apiari wa biro dokeno no bere kea ame puonye wa mamalo mo apiari wa biro Echel be training me mon angwen na papat me Echel bedo training ame mon duch be ye me ario tedo be i training me jo ame wo jo jo do man VVIP Echel doctor training kire me bayu jinga adon don kun mede karchel kire ngechu kene ame ubino upuonye karchel kire yo kire ame en unwo obere matame ufringe to lagaro now ngala mana me obere tieni yen unwo tedera karmi arioko obere tiye kaname lwak chipan obinu mboko ngame timere ikan ene ye tieni apilida Echel man lieutenant achie ngatame upuonye me gwoko president tido hatto atimobal ikom civilian do ena no kwao ni katwer ngol buch meto iwiche eka buchman no tieme twenya kino unyo chala kwenya kin bot umonyo kenne weke ko balman petimere ingola ame obeda tie lieutenant colonel Moses ame tele pirman beber won kome kot mon this speaker nana ngola tini beda tie tan yanka yen karshel kidi ngola me okiko mon katukere
ya point 12 an nyabere noni otieno abere speaker me Oyam district local government ata me luo kola Kizito Innocent ubere mina me atahere ento jaoke na mawane dishu bero tinwa me Oyam enemiyo wanu ni piretek ekoti chobere kitame chobere kede megama chek ana yeng karasiel kede kitame ngola oworo karasiel kede bang kano kod dishu ame kuwi yogana kan bero kitame kotu mon tiekere amita kobono bal nyodang toro luenyo man atichek ame atoro kobo nono kredang amitida ko man yendang piretek me kobo bang atutumia ario kerpia nono umon muyu PDF kong